Good day, everyone. My name is Scott Reich, and this is Crime Talk. Yes, this is the weekly recap of all the top stories we previously discussed throughout the week, all conveniently located in one location. So we enjoy it, understand it's the news from this past week. Hope you enjoy it. We'll see you next time on Crime Talk. Next on the docket, was Bryan Kohberger framed? Well, apparently, and I say apparently, a family member thinks so, but they did it anonymously. So take that for what it is worth. Now, obviously, Bryan Kohberger's been charged and arrested with the death of the 4 college students there in Moscow, Idaho. Well, needless to say, there's been a lot of talk about the Bryan Kohberger case on social media and, frankly, just about everywhere indeed. So there was a post that was made that says that they are a member of Bryan Kohberger's family. It's kept anonymous, so you have to take that with a certain grain of salt indeed. I truly believe that people, if they want to actually have something out there, they should put their name behind it. But this is somewhat of an interesting little twist. And like I said, unless you can prove it, that's the only thing that matters in a court of law, what you can prove, not what you think, not what you believe, but what you actually know. So this family member said, I'm posting this because Bryan is my family, and you people in this group act like vultures and rabid raccoons. Bryan is innocent, and you will see that he was framed by his drug partner friend, the security guard from the university. Now, the user, this poster, then claimed that Bryan was doing drugs in the parking lot, and the screenshot further reads that they were doing drugs together in the parking lot as they had done numerous times, but when security guard started acting like a peeping Tom outside the girl's window, Bryan left the security guard and drove back to his apartment. The screenshot also said the reason the phone was off is because the battery was flat and the security guard was using the car charger. Bryan put his phone on charge when he left the parking lot, and he switched it back on when he was near his apartment because that's how long it took to get a charge going. The post also notes that Bryan's knife was in the car and security guard was holding it because he had used it to chop the cocaine lines. Yes, I said cocaine because Bryan stopped heroin years back and substituted the drug with cocaine. The Facebook poster also notes that, quote, he has tried so hard to stop everything, but he's an addict and he had migraines, so the cocaine actually helps him. He had no idea security guard was going to do what he did and just wanted to teach security guard a lesson by leaving him behind. Bryan actually feels terrible that he left this maniac behind, but it's not his fault. And then the alleged Kohberger family member threatened that Kohberger and his father would sue people if they spread any rumors as per the screenshot. You people need to stop with these singing videos and funny pictures of Bryan and my dad, or we will sue you for everything you have. All of you just get a life and stop playing Facebook detectives. So I don't know. As you may recall, lots of family members in the Watts case hit to social media and responded to allegations and claims. I don't know. You take it for what it's worth, if it's worth anything at all, but we throw that out there for you to decide. Leave me a comment below. Was Kohberger framed? Security guard guy? Boy, and if that's the case, you think you'd probably want to let your defense attorneys know immediately so they could get the real killer. Let me know what you think.
Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado, CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. Was Bryan Kohberger messaging a victim? Well, it's now being alleged that Bryan Kohberger messaged one of the female victims weeks before the quadruple slaying and allegedly sent more direct messages after she allegedly ignored him. Now, somebody in the police, speaking on anonymity with a magazine, said that Kohberger reached out to one of the 4 University of Idaho students over Instagram repeatedly in an attempt to get her attention. So Kohberger allegedly DM'd several times, but there was no response. So basically, it was apparently him saying, "Hey, how are you?" But he did it again and again. Unknown at the time which student Kohberger sent these Instagram messages to or to who the investigators familiar with the case is that's talking. So this unidentified source said that whether the woman Kohberger allegedly messaged deliberately ignored him or if the messages he sent went into her requested folder from people she wasn't friends with. Those messages don't appear as alerts and are hard to see. So we do know that the victim, Kaylee Gonsalves, is said to have complained of a stalker in the run-up to the killings, but it's unclear if there's any link between this and her murder. Now, Mr. Kohberger has maintained his innocence in the stabbing death of Kaylee, Madison, Chapin, and Zana. We'll give him the presumption of innocence as well. But some people are starting to state that the evidence against Kohberger is beginning to pile up. We'll wait and see. But of course, since there's a gag order and nobody can make comments whatsoever, we're left to listen to anonymous sources. So I'm a firm believer that you have to take anonymous sources with some skepticism. Otherwise, why wouldn't they go on the record? If they're not willing to go on the record, you got to take it with a grain of salt. Now, the Instagram account in question apparently was viewed by this magazine prior to the site being taken down. Now, allegedly, Kohberger followed Mogan, Gonsalves, and Kernodle on various occasions, and apparently did not publicly interact with their accounts otherwise, according to this magazine. In these alleged messages now sent from this deleted Instagram, Kohberger appeared to be hoping to get the attention of the victim that he was targeting. The victim may have completely missed these messages. She may not have even seen them because they went into this message request, according to the source of this information. The DMs were allegedly sent in October, just weeks before the November 13th slayings. So when an Instagram user apparently doesn't follow back, attempts to send a message, it goes to a designated folder called message requests. These requests are located in a different place than the typical messages. The investigator apparently also has stated that they're still trying to determine how aware the victims were of this existence of these messages. The source also apparently said that Kohberger was definitely persistent in the message to the Idaho student, the unnamed Idaho student. Now, like I said, take this with a grain of salt, but we're putting this out there, but understand it's uncorroborated and it's from an anonymous source. You just, if they're not willing to go raise their hand and testify to in court or put their name behind it, like I said, you always have to take it with a grain of salt. Now, let's just say hypothetically that everything about this is true. So this guy sees an attractive girl at school, tries to, find her on Instagram and sends her a message. Hey, how are you? Hey, how are you? Hey, how are you? What's up? Doesn't necessarily mean that he killed somebody. Well, it necessarily wouldn't. I guess the prosecution's theory would be that, well, he was so obsessed with one of these young ladies that he became so upset and enraged that he was rebuffed by his alleged advance by sending a DM. I know that's the way young people communicate these days. They don't really ever talk to anybody because it takes actual guts to go talk to somebody face to face or pick up the phone and actually speak with them versus just being a keyboard warrior. So I don't know. We're going to have to wait and see. And we're going to have to see if this gets corroborated. Now, all right, next. Well, Steve Gonsalves, the father of Kayla Gonsalves, has shed a little more light on the 911 call placed by the roommates when they realized that something had gone terribly wrong. So we know there's been a lot of speculation about why the roommates didn't call 911 until around noon the day following the homicides. But Gonsalves gave an interview on Today, and he says, you got to remember, these two girls were so upset that when they went outside after seeing this, one passed out and the other was hyperventilating that the message wasn't clear enough for the 911 operator. Now, in the affidavit released, one of the surviving roommates said that she said a figure dressed in an all black and wearing a mask walked towards her. She then locked herself in her room. Police have still not identified a motive for this attack, and the probable cause preliminary hearing is not set until June 26th. Now, the upcoming preliminary hearing, where both sides can, in theory, present evidence, but it's going to be a discovery tool for the defense, and the prosecution is going to have to lay out their case to establish probable cause. Understand, at this point, the detective could literally get up and regurgitate what he put in his affidavit for the arrest warrant, and probable cause would be found. Probable cause is simply would a reasonable person believe that a crime was committed and that Mr. Kohberger committed it. Very low standard, not the same standard of proof at trial, which is proof beyond a reasonable doubt. Somebody asked a question, how could you hold somebody when they haven't met their standard? The standard is low. The standard is very low throughout the proceedings, unless and until at trial the prosecution can prove each and every element of the offense beyond a reasonable doubt. If the government failed to prove just one element of the offense, it would be the solemn oath and obligation of the jury to find any defendant not guilty. However, if the prosecution proves their case beyond a reasonable doubt, it is the solemn oath and obligation for the jurors to find the defendant guilty, whether it's Mr. Kohberger or any defendant. We'll simply have to see how all this evidence comes out in the future. Stay tuned. Do you know who's having a bad day? Alec Baldwin. Why is Alec Baldwin having a bad day? Well, guess what? The New Mexico prosecutors have charged Alec Baldwin for the 2021 fatal shooting of cinematographer Halyna Hutchins on the set of Rust. Now, Baldwin shot the bullet that killed Hutchins, and he and the movie's armorer, Hannah Gutierrez-Reed, each will be charged with 2 counts of involuntary manslaughter. Now, the Rust assistant director, David Holes, has already signed a plea agreement, apparently, for the charge of negligent use of a deadly weapon, resulting in a suspended sentence, which basically means we're going to put you on probation. But if you fail probation, we're going to impose a sentence for you down the road. And so this is a 6-month suspended sentence with probation. Somebody's already cut a deal. And that news comes from the district attorney themselves. Now, the DA's office had been waiting to review evidence from the FBI investigation since October of 2021 after the shooting took place. Now, once the office received the evidence from the FBI, the DA announced that she would intend to pursue charges and actually filed a $635,000 request for emergency funding to hire a specialized team, including a new prosecutor, investigator, and a spokesperson to handle everything that's going to come with the case. Now, the DA received about half of the requested funds, so I guess you get half the justice, apparently. No, they'll always find money for justice. They will find it. Anyway, for those who are not familiar, Helena Hutchins was shot and killed October 21st, 2021, during a scene where Baldwin uses a gun that was filled with live bullet rounds instead of dummies, which is against the Hollywood film standards. Joel Souza, the movie's director, was injured by the bullet, but he fortunately recovered. Now, David Hall, the movie's assistant director, admitted less than a week after the shooting that he had not properly checked the gun for safety before handing it to the film's armorer, Hannah Gutierrez-Reed, who would pass it along to Baldwin for the scene. Now, months later, in December of 2021, Baldwin said that he didn't pull the trigger, and the FBI forensic report said that despite Baldwin's denial, the gun could not have gone off without the pull of the trigger. The family of Helena Hutchins ultimately sued Baldwin and the film producers back in February of 2022 for wrongful death. The lawsuit was settled in October of 2022, and the movie resumed filming with Matt Hutchins, the widower of Helena, now serving as executive producer. So what is manslaughter? And what is involuntary manslaughter in New Mexico, where this case will be tried? Well, manslaughter is the unlawful killing of a human being without malice. Voluntary manslaughter consists of manslaughter committed upon a sudden quarrel or in the heat of passion. Whoever commits voluntary manslaughter is guilty of a third-degree felony resulting in the death of a human being. Here's the important one. Involuntary manslaughter consists of manslaughter committed in the commission of an unlawful act not amounting to felony, or in the commission of a lawful act which might produce death in an unlawful manner, or without due caution and circumspection. Whoever commits involuntary manslaughter is guilty of a fourth-degree felony. What's that as a fancy way of saying? It's a fancy way of saying, in this statute, this was involuntary manslaughter on a criminally negligent standard. That's what that really means. Now, it is a fourth-degree felony. What does that mean in New Mexico? It's the least serious of the felonies, but obviously it's a felony, which is quite severe because you could be sentenced to prison. You certainly cannot possess firearms after this. While you're on probation or some sort of confinement, you have collateral consequences, like you can't possess a firearm, and it can affect your ability to obtain loans, to be able to obtain employment, professional licenses, all those types of things that come with a felony conviction. So the crimes in this degree may include property damage, shoplifting, and items up to worth $2,500, including manslaughter, aggravated assaults, identity thefts, and possessions of controlled substances. The penalties of the fourth-degree felony in New Mexico include up to 18 months in prison and a fine of $5,000. So what that means is, since there's 2 counts for 2 victims, each could carry a maximum penalty of up to 18 months in prison. They could be served concurrent, run at the same time, or consecutive, one after the other. Do we really think Alec Baldwin is going to prison? No. What surprises me about this? These charges don't surprise me at all. If you go back and look at our previous videos when all this went down, I said it'll be some sort of criminally negligent based charge, and in fact, they have done that. Criminal negligence. Now, I got a real problem with criminal negligence in the criminal realm, all right? It's a civil standard, negligence. It's reasonable foreseeability. Should that really be criminal? Most criminal statutes that the government is required to prove a mental state, a knowing mental state, that someone knew what they were doing, they were aware of their conduct, and they were practically certain to cause the intended result. Negligence is a reasonable man standard. Would a reasonable person believe that there is a risk and is reasonably foreseeable, and that the person failed to act according to those risks? You know, if you rear end somebody in a car, you're more than likely negligent. Should it also be criminal? Well, it usually is. It's called reckless driving. But once again, it's a much higher mental state that somebody has to have the government prove in there. So that's one thing with criminal negligence. The other thing that surprised me is, why did it take over a year? The DA said that she was waiting for the FBI analysis of the firearm. That was concluded in October. 3 months to decide after you received that information, and the FBI said the firearm was functioning? Oh my gosh, you could have just watched CrimeTalk. We did a video where I brought in a very similar firearm, an actual antique firearm, and I clearly demonstrated that you cannot fire a round from that weapon unless somebody pulls the trigger. Impossible. So when Alec Baldwin says that that's what happened, he's wrong. Hey, if that's what gets him through the day, I guess he can do that. But the reality of it is that firearm did not just go off. It didn't happen there, Alec. So what will ultimately happen here? Well, will it be a favorable plea disposition? The prosecutors already made a favorable plea disposition to one person, a suspended sentence. It's a slap on the wrist. Maybe a misdemeanor. I can't imagine Helena Hutchinson's family is upset to the point they've settled the case. Obviously, their loved one is gone, but do they really want Alec Baldwin to go to prison? I guess what that really comes down to is what does Alec Baldwin want? What does the armorer in this case want to do? My guess is it will result in some sort of plea disposition. I'd be very surprised. I'd be very, very surprised if this went all the way to trial. First, there is going to be a trial in the Lori Vallow and Chad Daybell matter. Judge Boyce denied a request to postpone the murder trial for Chad Daybell and Lori Vallow, and they will not be permitted to have face-to-face meetings or phone calls to prepare for trial. That's right. Judge Stephen Boyce made the ruling during a 2.5-hour court hearing Thursday in Fremont County. Now, Lori Vallow Daybell appeared in a pink blouse and a dark dress pants, while Chad Daybell wore his traditional white shirt and tie. The couple rarely looked at each other, and their attorneys argued motions on their behalf. Now, cameras were not allowed in the hearing because Judge Boyce completely gave in to the prosecution, so no videos. Anyway, Lori and Chad are charged with multiple counts of first-degree murder and conspiracy to commit murder for the deaths of 7-year-old Joshua J.J. Vallow and 16-year-old Tylee Ryan, two of Lori's children, along with Chad's previous wife, Tammy Daybell. Now, Jim Archibald and John Thomas, who are Lori Vallow's court-appointed attorneys, filed motions this past month asking for permission for Ms. Vallow to meet in person and have a phone strategy session ahead of the April trial date. The two defendants would like to be able to talk about their settlement options, according to Mr. Archibald's pleading, noting that the prosecutors sent him a letter asking if Lori was interested in settling the case. We need to be able to talk settlement and plan strategy as we prepare for the settlement conference, as we prepare for mediation. Mr. Archibald was asking for an order from the court, and he would like to have that decided today. Well, Mr. Archibald said that Lori and Chad, along with their attorneys, would attend this meeting, and a sheriff deputy could stand outside the door for security purposes. He requested regular conferences, which would not be recorded or used in court. Now, the Fremont County prosecuting attorney, Lindsay Blake, expressed significant concern over such an idea, and she said that each defendant has an attorney-client privilege with their respective counsel, and they do not have the same privilege with their co-defendant's counsel. Yeah, unless, of course, there's a joint defense agreement, but nobody wants to talk about that. Anyway, she mentioned that if Chad said something incriminating in front of Lori's attorneys, they then become witnesses and are not protected by the attorney-client privilege. Or you could always have your investigator sit there, and if there's a witness statement that is made, then the investigators could testify and not the attorneys. Duh. She also addressed settling the case. Quote, there can be no settlement conference if the state is not a party to that conference. The request is not to have the state present in these meetings, so there could not be a settlement negotiation unless the state is there, she argued. Well, sure they could. I mean, I don't know how they do things in Idaho where everybody sits around with their defendants there. Never done that. But let's face it, that's just not going to work. So Mr. Pryor, Chad's attorney, expressed support for the meeting, but took issue with the word strategizing. He said, quote, I'm not going to strategize with anybody. I'm going to present our defense in this case. Now, That's an end quote there. The process is going to be trial prep. There's going to be no strategizing. This is trial prep, which is kind of synonymous with strategizing. Just saying. Anyway, Judge Boyce said he understood the rationale for the request, but explained it's an idea full of pitfalls that would far outweigh any consequences before he denied the motion. Now, prosecutors argued that the jury should be sequestered when the trial begins on April 3rd up in Ada County, and the trial is scheduled to last for 10 weeks. The prosecution is worried, given the nature of this case, given the publicity, that if the court does not sequester the jury for the duration of the trial, there's going to be problems keeping the jury secure and making them have no contact with parties about the case. Now, the prosecutor acknowledged sequestering a jury is a costly hardship for jurors, but said the seriousness of the case requires it in this particular matter. She said, quote, "This case involves the death of 2 children and the death of a mother of multiple children. If there are no safeguards provided to jurors, given the attention of some of the citizen journalists on this case, we have real concerns about the integrity of the case," end quote. So basically, she's blaming everyone out there except the press for somehow that they're going to disrupt the jury process. Give the public a little more credit. Now, I understand there's always somebody that's going to maybe do something stupid, but that could happen even if the jury is sequestered. And that's expensive to house the jury for 10 weeks, feed them, make sure they're not getting any newspapers if anybody reads newspapers. How are you going to limit what shows up at their feeds on Facebook, Instagram, all that kind of stuff? It's called an instruction by the court admonishing the jury not to read anything about this case if you're on the jury. You can't consider anything if you are on the jury that comes from any outside source, anything other than court. That's how the problem is solved. Now, Mr. Archibald noted that he would normally agree with sequestering a jury in a high-profile case, but the trial length worries him, and therefore he is opposed to the motion. And having the jury sequestered for over 2 months, no contact with home, no contact with children, it's going to limit our jury pool, he argued. And our jury pool is going to consist of who? Retirees. Nobody with a job. Nobody with a business to run. As my professor in law school once said, the citizen jury. 12 people good and true, otherwise unemployable. I'm going to give the Idaho jurors more credit than that. I think that they will all take their jury duty very seriously, regardless whether they're unemployed or retired. But let's face it, probably not the ideal juror for the defense in this particular case. Anyway, Mr. Pryor also objected to sequestering the jury and argued that the Ada County and Fremont County Sheriff's Office could provide adequate security for the jurors. The only thing you're doing is stopping a bunch of jurors from reading the paper or getting on the internet. You can instruct them about that, Judge. You don't need to lock up a jury for 2 months like prisoners, Mr. Pryor argued. I agree with Mr. Pryor. Just saying. Judge Boyce said he understood the position of both sides, but denied the request to sequester the jury. He said, quote, "I believe adequate steps can be put in place to not require sequestration during the course of the trial, and that the court will take those steps very seriously," the judge concluded. And Mr. Pryor asked the judge to delay the trial until April of 2024. That's right, over a year, as he is awaiting potential DNA evidence from the Idaho State Lab that he worries will take time to get back. He stated, quote, "There is no way that the DNA evidence will be done, and even if it is provided to me tomorrow, I am going to need a specific time to have my expert test it and make their own conclusions," he argued. "And if I don't get the evidence, Mr. Daybell is going to file an ineffective assistance counsel claim against him. And as much I like Chad, he's going to do it, and he won't hesitate to do it. Then this case will be turned over because I was not provided an adequate opportunity to prepare." Yes, the old ineffective assistance of counsel argument that I have raised many a time for myself when I needed more time. The judge noted that. He gets it, and he's basically saying, "Judge, my client's going to say I was ineffective." So the judge then inquired of the prosecutor, Miss Lindsay Blake, as if there was any currently outstanding evidence that has not been disclosed. Remember, We're talking 3 years now. And the prosecutor said that there was potential source of DNA evidence that was located, and that the state lab personnel does not believe through testing they are going to get any DNA back. It could be exculpatory. They simply don't know. The state lab was going to test those items, but were not hopeful they could get any DNA. Needless to say, the prosecutors objected to delaying the proceedings, and Judge Boyce said his hands were tied because the case is joined with 2 defendants, and one of them, Lori Vallow, has not waived her right to a speedy trial. He said the overarching concern is that one defendant, Mr. Daybell, is requesting to have it set another year out. The co-defendant has unequivocally asserted her right to a speedy trial. She has never equivocated at all about wanting things to go without delay. And the court said, I would be very concerned if I were to set a trial out for another year in April. That's right. Speedy trial is a thing, and the court must accommodate that request for a speedy trial. Ultimately, Judge Boyce denied the request to continue, but said he will not force Chad Daybell into a trial if he and his attorney, Mr. Pryor, have not had enough time to examine the evidence. So he said, quote, if we are on the eve of trial and the state has exculpatory evidence and did not provide Mr. Pryor enough time at that point, the case may be severed, end quote. So the judge is saying, hey there, Miss Prosecutor, if you're going to test your evidence, you better get it done. You better get it done now, and you better give it in sufficient time. Otherwise, that severance that you don't want, you may just get it. So be careful what you wish for. You delay testing DNA this late in the game, literally a couple months before trial. Very dangerous. Very, very dangerous. And as you may recall, Lori Vallow's attorneys filed 4 motions asking Judge Boyce to take the death penalty off the table. And Mr. Archibald acknowledged that the motions were routine in death penalty cases, as we've talked about, and admitted that they would really not get a whole lot of traction unless they were heard at the appellate court level. Still, he argued the death penalty is flawed, expensive, and it brings a bias to jury selection. Because as a death penalty lawyer, he's done many of these cases, and we try to settle before we get to that point. He said some death penalty lawyers would say if you're already in trial, you've lost because the jury is prone to convict, and simply give a death penalty because it is a death penalty case. He argues that the jury is basically given a license to kill. Mr. Archibald then went through the 8 cases where people are in death row in Idaho, one of who has been awaiting the death penalty for 30 years. He said the process was long, complicated, and rarely led to an actual execution. He says, why does Idaho seek to kill someone when they have no intention of carrying it out? He says their process is flawed, it's replete with mistakes, and the appeal process will go on forever if the state receives its wish of a death penalty. In this case, that's why he is asking the court to stop this nonsense now and rule that the capital punishment scheme is unconstitutional. Now, the prosecutors obviously objected to the idea of dropping the death penalty and said the prosecution's case will prove Lori Vallow intended for her children and Tammy Daybell to die. Judge Boyce said he would take the death penalty motions under advisement and issue a written order. Mr. Archibald, I know you submitted these kind of boilerplate motions, and I'm going to go dig through the court's files and somewhere find a boilerplate answer so I can prepare the order in this particular case, because everybody knows it's simply not going to happen. Now, for those who are not familiar with the case, Chad Daybell and Lori Vallow, who are technically married, have pled not guilty to all charges. The next hearing that they are scheduled for is February 9th of 2023.